Why don't we get started? I want to thank you all for being here. My name is Roger Royse. I'm a partner with the law firm of Haynes and Boone. I'm resident in the Palo Alto, California office, heart of Silicon Valley. Haynes and Boone is an Am Law 100 law firm with offices all over the country and other parts of the world, including London, Mexico, and China. And hopefully soon to be some additional locations. I work with startups. I do emerging growth and venture capital, and I'm on both sides of the deal. And in the sense that not both sides of the same deal, but in a sense that I work with both investors as well as investees. But mostly what I do is startups. Mostly I represent the companies. I think that's more fun. That's more interesting. I get to see more cool stuff more often. So that's kind of my thing. And that's what we're going to talk about today is legal issues for startups. Now, before we get going, I do want to make a couple of housekeeping and other announcements. First of all, in terms of format, if you've been to an ID to IPO event before, you know that our format is 1 hour of presentation followed by a half hour of Q&A. So save up your questions, put them in the Q&A box, and then I'll get to them at the end of the presentation. Or I'll try to get to all of them. And if I don't, I'm going to save the chat and I'll definitely follow up with you afterwards. I'm going to record this presentation. We're recording right now, so I hope that's okay with everybody. If not, then hide your name and don't say anything in the Q&A or whatever. But we are going to record it, and I'm going to send you a copy of the recording. I'm going to send you an email. It's going to come along with, it's going to come from my site, 10,000 Startups. So don't be surprised when you see that. And of course, I'll ask to add you to the mailing list. And if you don't want to be added, that's fine too. But I do regular updates on legal issues that are of relevance to startups. And I don't do that often. Maybe every couple months you'll get something from me or announce an event, because we do tons of events, most of them online. Speaking of which, the next event that I'm going to be doing for ID to IPO is going to be Sunday afternoon, because I hear there's nothing else going on in town. Oh wait, there's a football game that day of some sort. Yeah, so instead we're going to do that on February 29. It's at 9 a.m. February 29. It is how to get angel and venture funding for your startup. And it's a much different topic than what I'm going to talk about today, and probably one that may be a little more interest to you. Today is going to be technical legal stuff. February 29 is really just what I've learned from being here in the Valley since 1991 and working with VCs and angels. I will also send you a digital copy of my latest book, 10,000 Startups, Legal Strategies for Startup Success. And if you want a hard copy that you can put on your bookshelf and carry with you on the bus or whatever, you can have one if you go on Amazon and buy it. But otherwise, I'll send you a digital copy because I'm not trying to get rich off the book. I'm trying to get the word out, so people understand what to do, so they don't make a lot of mistakes that I have to clean up later. Okay, and then finally, I am going to post one more time all of my LinkedIn, etc. The YouTube channel where you'll find this recording. I also have a blog called 10,000 Startups. Please subscribe to my blog on Apple Podcast. I'm sorry, not a blog, a podcast. Please subscribe to the podcast. Every Monday, I do about 20 minutes on an issue of interest to startups, very accessible to anybody. All right, with that, why don't we get going? So again, the topic here, it's a little negative, legal mistakes that could doom your startup. But it's relevant, especially today when it's just so easy to just go online and do everything yourself. And I see a lot of companies do that. And in fact, I'd see a lot of lawyers, maybe most of them that I know these days, that they won't even do an incorporation anymore. They'll just send people to an online website, which is all fine, but because it kind of weeds out the companies that are never going to get to the next stage, which is most companies. But I prefer not to do it that way because I would rather not see it. And I've seen this so many times in my career where the startup, you manage to address that perfect storm of the right team and the right product and the right market fit. And now you've got the right investor and everything is perfect, but you get stalled and maybe irretrievably by some very simple legal mistake at the front end. Well, what are those legal mistakes? We're going to talk about that. And it's great that you're here because this is stuff that you really need to know because your lawyer might not think to ask. And you need to be aware, and certainly you need to be aware to raise these issues. And I don't know if I've got exactly 10, but I'll try to do it that way. Sorry, forgot to take my daily aspirin. All right. First one. Claims by prior employers. So here in Silicon Valley, especially, we've got everyone's got a side hustle. Let me put it that way. Everybody on nights and weekends is working on their startup idea, and you can't help it because you look around and you see so many people doing big things with a great idea, and most of them they launch in garages. Well, that's important that you keep it in the garage and you don't take it to your office at your day job, because the very first question I ask founders when they come to me, before they've even formed a company, when they're just thinking about it, is, gee, are you sure this idea of yours belongs to you? Is there a prior employer around that might be able to make a claim to it? Well, you got to know four things. And three of them are pretty easy. Number one, you should have done this on your own time, not while you're being paid by somebody else. That's a problem. Secondly, you should be doing it with your own facilities, not with your employer's computer. That would also be a problem. Cloud's title makes it possible that the employer might have some ownership in whatever that opportunity, idea, or even IP is. Thirdly, doesn't result from work performed for the employer. Employer asked me to create a widget and I ended up with a gadget. Well, that's a problem. I think the employer probably owns that, certainly has rights to it, certainly Cloud's title. You might get a demand letter on that if you try to go start a company around it. It's the fourth one that's a little bit tricky, and that's where you got to go read all the cases. Or better yet, ask me to read them and tell you what they mean. But that is your new business really should not be related to your employer's business. Well, what does that mean? How closely related does it have to be? And I wish I had a nice, clear, bright line, but I don't. This is one of those fuzzy things where we really want to plan into this and make sure that if you are going to start your side hustle, your business, your startup on your own time with your own facilities, we want to make sure that we put as much separation as possible between that company, your new company, and your current employer. And for God's sakes, I prefer that you not announce, not launch, we'll say, while you're still employed by somebody else, unless you can get your current employer to agree to it. And they will often do that. I just did a deal not too long ago as an M&A, very successful M&A, close to $100 million for two founders who worked for a very large software company. They have full-time jobs with a software company here in Silicon Valley. The company that made them rich, their startup, I don't know, looked pretty close to me to what their day job was, but we anticipated this problem. And they just went to their employer and say, hey, Mr. Employer, I got this hobby. I'm working on this. Won't interfere with my duties here. I promise you'll get my full employable time. But my lawyer's really nervous. He's a nervous Nelly. He'd like you to just sign this little document that says you waive any rights to it. And they did, because they're good employees. They want to treat them well and problem solved before it even started. started. So that's the best solution. All right. Best practices, a couple of other things I want to mention. Your current employer will undoubtedly have asked you to sign a confidential information agreement and invention assignment, which goes as far as it can under California law. We'll talk about that in a minute. And assigning to that employer everything that you do for that employer. I'm going to talk about that more specifically. And your new company, when you start bringing in founders, you want to avoid claims by their prior employers, not just founders, employees, especially salespeople. So you similarly will be, and you want them not to take your IP and take it to their next startup. So you similarly will be putting that document in place. It's a fundamental, essential document. Every company has it when they start up. If they don't, it's because somebody didn't get a signature. Secondly, when you do bring on people who were employed by somebody else, especially in a related industry, which is almost by definition going to be the case, right? Or they wouldn't have the skills that you want. You don't really know 100% what it is they did for that prior company, or how they did it, or what agreements they have. So the best practice is to make that new person sign a representation that basically says, look, I'm not going to cause you any problems by going to work for you. I don't have, I'm not stealing any IP. I'm not bringing a mailing list with me. I'm not downloading files on my last day of work. I'm not doing anything that would cause my former employer to send you one of those nasty demand letters after I start here. And I have sent those letters and I have replied to those letters. Very common. Get those representations. That's really significant. Not because it has I think it helps if there ever is a claim against the company, the new company, but mostly because it just focuses people on the issue. And if these are well drafted, you want to draft it in such a way that the new person you're bringing on would basically have to lie to you for that not to be correct. That's how you want it to be that clear. And then finally, like I say, I would avoid social media until you actually know you're well in the clear. So certainly while you're working for Big Co, you don't want to be posting all over about all your work for Small Co, unless Big Co knows about it and is waiting. All right, next, documentation. And I tell people that I see this is the number one mistake. It's a dead on arrival mistake. And those of you who read my first book know about this. The first book is called Dead on Arrival, How to Avoid Legal Mistakes That Could Kill Your Startup. But this is number one. And what I tell people is during my almost 40-year legal career, I've practiced in a lot of different areas. I've been out in the oil patch in North Dakota. I was in the agricultural area for a long time. I was in Wall Street, downtown Manhattan, New York City, working with investment bankers and the wolves. I've done some work down in Hollywood in the movie industry, and I settled here in Silicon Valley to do tech. Half my work is international, just working around the world in other countries. And there's one common theme among all of those different geographies, industries, practice areas is just the tendency for business people to view formalities as being a little silly and unnecessary. And it ranges from, my word is my bond. I do business on a handshake. If you don't like that, then you don't trust me, and blah blah blah. I've heard that so many times. It ranges from that to, if it's not in paper, it didn't happen. Well, I lean a little towards if it's not on paper, it didn't happen area, because I'm a lawyer and I want to resolve issues before they happen. Well, what are those issues? What are the problems that happen from not having documentation? Here's the number one problem. Number one problem is people don't document their equity ownership. They work forever on it. You meet somebody at a hackathon and you come up with a great idea and you start building it. So you just don't put anything down on paper, not even a napkin. And by the way, it's surprising how little paper you need to prove your case. And it's not as bad now as it used to be because we have email. When I started practicing, we did not. So our corollary was bar napkins, which trust me, believe it or not, I've seen a lot of bar napkins with agreements written on them. So that's how we used to do things. So that helps a little, but the more formal you are, the better off you are, because people will change their minds, or they might have different expectations, or you might have told your founder, you might have been thinking that you and your co-founder are going to be 60-40, and they might have been thinking they're going to be 60-40 too. And you might think you were thinking the same things, but then you come to find out that, oh no, you were thinking very different things about that 60-40, who has the 60 and who has the 40. And that's a dead on arrival issue, because if you can't get people to agree on equity ownership, just forget about it. That's for the guy from Philly. Is that what you're saying, Philly? Forget about it? Or is that New York? Because your investor is not going to invest in an equity squabble. I mean, generally, unless you are super hot. So that's number one. Second is vesting. So let's say we've all agreed on the equity split. Well, you're all thinking that, but of course everybody vests, right? You don't just start out owning a third of the company from day one, right? You got to vest. You have to earn into it, and that's what vesting means, right? You earn your shares over time. So, for example, if I'm vested in 300, if I'm vested 3 million shares on a 3-year vesting schedule, that means that the company, if I leave during those 3 years, the company can take back at cost, which is close to zero, the unvested shares. So after 1 year, I get to keep 1 million, they take back 2 million. After 2 years, I keep 2 million, they take back 3 million. You get the idea. I typically do it monthly. I typically do it with a 1-year cliff, meaning you got to stay 1 year before you're vested in anything. Because if you can't stick around for a year, you shouldn't get anything. That's the theory. That's market. That's standard. Nevertheless, it's not legally enforceable until it's in writing. Okay, so I want, so that's a problem. That's a big problem. People, they have their napkin that says we're a third, but they don't have the napkin we're all going to vest. And then somebody leaves, and it's like, give me my third. And then the company says, well, yeah, but you haven't been here a year. You shouldn't get anything. And they said, that's not what the napkin or the email says. So I like to get that in writing. Thirdly, now it gets to be a little more subtle. I've seen this over and over. The company gets going and people are just, without a lot of paper, are making contributions, and everybody's putting time in for sure. And somebody there, Daddy Warbucks is in there in the mix somewhere, who's got the money and is putting money into this and paying expenses, or advancing this or buying that or doing this. And nothing really gets papered until you have to go to the accountants. But it's going to be a while before you get an accountant. You're probably on QuickBooks or something until then, if you're lucky. Maybe not even that, maybe just Excel. And that's interesting, but not an agreement. So where does it become a problem? It becomes a problem when you finally get to that inflection point where you're going to get financing, you're going to get sold, you have revenues, whatever it is. And the person who puts the money in, they're going to say, look, I always intended that this was a loan and I get paid back at close of financing. Or they say, I always intended that my money I put in was going to convert into preferred stock when we do a financing. Or they say, I always intended that I was going to get more common stock at that real cheap founder's price for my money. In fact, they probably didn't think about it. But at the time when we have to characterize that money on a disclosure schedule, because you've got a new investor coming in, I can promise you they're going to do whatever is most favorable to them. So let's avoid that problem. Let's have like a really super simple board resolution, or something, a side letter, something that basically says, Joe's $100,000 that he just put into the company, we hereby approve a loan from Joe, bearing interest at the applicable federal rate. That's a tax thing. It's super low. And ideally, I'd love to see a loan agreement. I'd love to see a promissory note. The IRS would too, by the way. So again, at the risk of over lawyering, that's one that a little bit of paper will go a long way. All right, a couple of other issues. People now, I used to be concerned about the fact that anybody could go online and incorporate their company and make all sorts of what I call dead on arrival mistakes in the incorporation, things that can't be fixed. And will turn an investor off. And then they come to me and we kind of tear up all the paper and start all over. That doesn't happen that often anymore. I mean, I'll be honest with you, the online incorporation tools are really good now. So if you just stay within the cookie cutter narrow confines of what they can do, we can with minimal effort clean it up later. If you try to get creative and say, if you try to use that sledgehammer when you should use a scalpel, then we're going to have problems. All right, that's one thing. What's happened since then, though, is the online safes, simple agreements for future equity, as well as the rest of them. The KISS, the keep it simple, stupid instrument, the convertible notes, all the stuff you can go online and download and get yourself in trouble. So now it's super easy. Any company can go sell securities without knowing anything about securities law. I have run into two people in my career, but in the last 10 years, two people that went to prison for violating securities laws because they did it all themselves, and it's just so easy. Of course, there was a little more to that, but you might think, oh, gee, they were committing fraud. Yeah, a prosecutor thought so, but in both those cases, I don't think so. I think they just screwed up. They just didn't know what they were doing because they were both pretty guileless, in my opinion. They just weren't careful. And in securities laws, I told a reporter last week, the rule is seller beware. You better be careful because you're making representations and they better be true. It's so easy now to just go out and download a document and, subject yourself to a bunch of laws you don't even know apply to you. So and I know there are even lawyers out there that will say, hey, don't bother me I don't make any money drafting, a one-page safe. Go online and download it and sell that and come back to me later. I'm never in a million years going to tell you to do that because 99 times out of 100 that might work, but it's that one time in 100 that there are just disastrous consequences. That's one thing. We can fix that pretty easily. Because honestly, complying with the securities laws is super simple once you know they apply. Most of the time, not always, most of the time. For my typical Silicon Valley accredited investors who live in California, not a problem. The bigger problem is you might not know what's in that document. And if we don't run out of time in the next half hour, I'm going to talk more about the Y Combinator post-money safe. But this requires a little more thought than people put into it. And I have had it happen more than once that I've had companies go download those online safes, get a bunch of investors to sign them, not really understanding what they say. And until the equity investor comes along, the VC, and then they have to convert all those safes and I see how much of the company they gave away that they didn't know. And I've had it happen more than once where the investor says, holy cow, you gave too much of your company too soon, too cheap. After I take my share and the safes takes their share, there's not enough left in this deal to incentivize the founders. We're out. Sayonara. We're going to, they say that in New York, don't they? Someplace else. We're going to the next company. Okay. So the good news is the internet and technology has helped solve this problem because there are online tools, and the online cap table services will provide tools to let you do what ifs. So you can take a picture, put in some assumptions, take a picture at any given time where you stand in the equity stack and what your percentage is. So my caution here is to be careful. And we've talked about online incorporators. Debt on arrival issues, I mentioned my main one, unsigned agreements, notes and emails. Yeah, you should definitely subscribe to my podcast. I'm gonna put the link here because the very first one I did was with Tom Moore in our office, a litigator, talking about litigation over notes and emails and evidence. And the thing that came through just so loud and clear is that, if you do get into a dispute, um, witnesses are going to say whatever they need to say to advance their case. I mean, it was a shock to me, even as a lawyer, the first time I discovered that people will lie in court. But if it's in writing, that goes into the jury box with the jury and you can't change it. If it's in writing, it's right in front of them. It's there. It's powerful. It's powerful. So, that's the note on that. Okay, let's talk a little more about vesting. Not a lot. I think everybody here knows what it is, but I just want to make a couple of points. I explained vesting a minute ago. That's the idea that you earn into your shares over time. Investing is enforced through a repurchase agreement at cost. So you get the shares today, but then if you leave, the company buys them back. By the way, you know why we do that, right? Like, why not? Because every once in a while, I'll have a company that will just insist we're going to give shares in tranches. You stay here a year, you get this many shares. You stay 2 years, you get another tranche of shares. The reason companies don't do that is because the value of those shares is going up over time. And if you give somebody shares a year from now that are worth $100,000, instead of giving them today when it's worth $1,000, well, guess what? If they're a service provider, they've got $100,000 of income. So the reason we do vesting is so they have $1,000 of income today. It's usually zero for other reasons, instead of $100,000 later. And then we just take them back. Anyhow, founder vesting. 20 years ago, maybe even more than that. Yeah, even longer than that. Since I've been in the Valley, 4 years seems to be the vesting schedule. Sometimes founders get away with 3. I guess most of the time I do 3, 4 for everybody else, 5, for a lot of people. Anyway, so it's in that 3 to 5 year range, right? So why is that? Where did that come from? Why is that the market standard? And I will tell you why. It's because there was a time before Exxon and not Exxon, before Broadcom, WorldCom, etc., when companies could go public. Before Sarbanes-Oxley, before Dodd-Frank, there was a time when it was a lot easier to go public. And companies, if they were really hot, that was a real thing. They were going to go public in 4 years. That's what everybody expected. So it made sense to have a 4-year vesting schedule. If you're as old as me, you probably remember the times that nobody got any work done because we were sitting on E-Trade all day, day trading, because so many companies were going out. Yeah, those days are over. Companies don't go public that often. I took one public last year, but it's honestly, most of my company's exits are M&A. But the fossil of a 4-year vesting schedule has stuck around for 3 years. So what does that mean now? If it's going to take a company 10 years to exit now, when it used to take 4, but we got a 4-year vesting schedule. So your VC comes along at year 3.5, and they need to keep you incentivized, for another few years. They're going to insist that you reset the vesting schedule. You start all over. Now, that's a negotiation because keep in mind, you could get kicked out of the company, sometimes. I mean, hopefully you got protections against that, but something could happen and you don't want to lose all those shares that you worked so hard to get over the last 4 years. On the other hand, you got to get the money. You got to get across that valley of death and get that new institutional money in. So we'll negotiate some vested shares and we'll reset and start revesting all over in some other shares. The reason I'm spending so much time on this is I think you ought to get it in your head that it's not likely that whatever your vesting schedule at inception is going to be your vesting schedule for all time. It's probably going to get reshaken once or twice before you're done. So note that, and also note, and I don't know why people are surprised by this. If the investor, the skill set that it took to start a company is not the skill set it takes to scale it sometimes, or not the skill set it takes to go into other markets. It's not the skill set. The skill set you need at seed is not the skill set you need at Series C, or at exit, or certainly not for a public company. So management will get changed around, and eventually you are going to lose control of the board. So you have to be prepared for the fact you might not be there forever. Single versus double trigger. Briefly, you're probably thinking that, okay, I'm okay with this 4-year vesting because Royce says it's going to be 10 years before we exit. But you know what? What if we exit sooner? What if we sell this company in 2 years? I think that if Big Co acquires us in a stock for stock deal, I think I should be fully vested. I don't think I should have to continue to vest after that change of control because I've done my job. I got you to an exit. Okay, fair point. Or you might be thinking, all right, I'll go along with that vesting schedule, but now I'm scared because I heard this presentation. I hear that people get fired sometimes and they lose all their unvested shares. And it might be not for cause. I mean, it might be just because there's 3 founders and 2 of them don't like me. And what do I don't know. Or it might even be for cause, because cause, you gotta be careful about that cause termination definition. It's pretty darn broad. Oftentimes includes things like a felony. Well, you'll be a little surprised at what constitutes felonies sometimes and what would be grounds for your for-cause termination. Whatever, you might say, if it's not my fault, or if it's something pretty mild, then I shouldn't lose my unvested shares. Fair point. You almost never get that. What you will get, if you're a senior person and not rank and file, is double trigger. Now, double trigger means both those things have to happen within a certain amount of time. You have to be terminated without cause, and you have to be terminated without cause within a certain amount of time, usually 6 months to a year, of a change of control of the business. And the concept is, look, if the company gets sold and I was a CFO and they don't need another CFO, so now all of a sudden I'm redundant and they fire me for that reason, I should get a little extra vesting, maybe even 100%, but certainly more than what I'm vested in as of that day. That the C-suite people will get if they ask for it. But that's about it. That's about it. Now, what I would recommend against doing, because I see this in documents, and I don't think I have ever once in my life done this, but I have seen it in documents often, is people will not really think so much about it, and they'll put a single trigger vesting condition in every stock, in their stock option plan, in all of their stock purchase agreements, in everything. And I think it's a bad idea because it increases the cost to an acquirer. That means it decreases the amount that everybody else is going to get. Why do I say that? Because when the acquirer comes along, they need to know when they acquire a company as a going concern that people are going to stick around. Well, are you going to stick around if you're not vested? No. So they got to give you an additional grant, or they got to go back and renegotiate. And if you got 100 employees or 50, even a dozen employees, who wants to renegotiate with every employee about revesting, unvesting? So they'll do an additional stock grant. Well, that's going to come out, they're not going to, that's going to come, someone's got to pay for that, right? Probably the sellers. Case of ZIP advisor vesting, quick point. Most vesting I said was like 3 to 5. Advisor is always 2, almost always 2. And it's tied to milestones because advisors aren't really showing up at work every day. So it's not a time-based thing. It's a milestone. You get me this many customers, you get this vesting. That's just word to the wise. Put a milestone in there. Otherwise, you'll never know if they're doing their job. Case of Zipcar, you can read all about it in my book. 2 founders, no vesting. One was a worker bee, one was a slacker. They had a lot of resentment. The VCs came in and straightened it all out later, but it was a lot of energy and probably cost them some valuation points. All I'll say about the tax side is be sensitive to tax, because vesting has tax consequences all over the place. And given a time, I'm not going to drill down on this now. You can Sir, like I say, you can read about this in my book. I'm just saying that there are tax consequences to vesting. This is one place where I'm really nervous about the online incorporator tools because you're going to require tax advice on this, or at least be knowledgeable about it. And it's a little tricky when vesting restrictions get imposed on financing or an M&A. And it's a long story, but I go into it in depth in my book. And you would be wise to read that chapter if you want to know about vesting. Okay, tax planning. All I want to say about, because I want to get to the new stuff that's happening. All I want to say about tax planning is that very little thought goes into it these days. Everybody's a Delaware C Corp. The C Corp is a separate taxable entity. It pays tax on its earnings and then distributes the rest to the shareholders. Nobody seems to care because how many startups have earnings, right? In my world, if you have earnings, you're doing something wrong. You should be reinvesting those earnings into building a huge goodwill asset that you're going to sell and exit and not pay any company level tax on. Once in a while, people will start as an S Corp, or they'll start as an LLC, and then we'll change it to C Corp later when the VCs come along, because all a VC will invest in is a C Corp. I'll just tell you that right now. There's a lot of reasons for that. Again, I go into it in my book if you're curious. And that's all fine, except for one little thing, that's QSBS treatment, qualified small business stock. Now, listen to this. If your stock or the stock your investor buys in your company, or if you got a really aggressive tax plan, or even that's safe to be invested in, if that's qualified small business stock and they hold it for 5 years before they sell it, they have a full 100% exemption from federal income tax. The exemption amount used to be less, 50 and 75% for stock granted a long time ago. We don't have to go into that detail right now. Just understand for these new investments, 100% federal exemption. And if they're like most of my VC clients who moved to Austin, that's basically, they're living in a tax haven. That's tax-free income, no state tax, no federal income tax. Holy cow, I pay 50% on my income. But if you're an investor in a state like that, buying only QSBS, you're paying zero. You've doubled your income, basically, your after-tax income. So that QSBS exemption is really super important. Well, only a C Corp can issue QSBS. So if you formed as an S Corp because you want to avoid payroll taxes, which is why people do that. That's why Joe Biden formed his S Corp. And no knock against Joe. I mean, that's the right thing for him to do for his book royalties. I mean, he's not going to get a VC to finance that, I don't think. So if you formed an S Corp and you've issued stock to yourself, well, now you got a problem because your stock is not QSBS, not even after you terminate that S election to become a C Corp. Now, the new investors coming in after it's a C Corp, they get QSBS. It's a little different with an LLC. An LLC can't issue QSBS either, but it can incorporate, and in the incorporation, it is going to issue QSBS to the founders. Now, this is a very involved area. It's tax, it's complex. I will tell you that I've got a hack for the S Corp problem that we regularly use. So we can get you out of that problem if you're well advised and forward thinking. And I talk a lot about it in my book. And I think it's even in the slides later. The LLC similarly, but we have to do some math to get there because if you do incorporate an LLC later, not all of your gain is going to be QSBS on an eventual sale. Let me just say it that way. Now, given what I've said, you might be saying, well, why does anybody ever do anything other than a C Corp? And I'll tell you why. It's because a lot of times a company doesn't really know who they are, right? Okay. They might think that they're going to be a lifestyle business that's going to throw off income every year. On the other hand, they might be scalable and venture financeable. We don't really know. So there's a way to wait and see without doing anything irreversible. You start as an LLC. And if it turns out that you really do have a change the world technology that the VCs are going to be the path to your door for, then we convert that to a C Corp down the road. So that's why we might do it later. The S Corp, you better be more certain because it's more difficult to make that conversion later. And I've got a chart in my slides, which I will be emailing to you. If you want to dig into the details to what all the differences are between these three entities, you can do that. And also you can see what it takes to qualify as qualified small business stock. But I want to keep moving here and talk about some of the other interesting stuff because we've got 14 minutes left. Okay, California, as everybody knows, has had a lot of changes in their employment law over the last several years. There's a long tortured history that starts off with the rideshare companies and a certain legislator down in Southern California thinking it's kind of unfair that rideshare, Uber drivers don't get the protection of an employee in California, even though I think most of them did not want those protections. They'd rather have the autonomy of being able to be independent. California sort of reached a compromise for those folks where they do get certain benefits of an employee. And it's almost like you got this round hole in this square peg. And for my whole career, we've been trying to fit people into either the round hole of an employee or the square peg of an independent contractor. And more oftentimes, really, they're somewhere in the middle. They're kind of a little bit like both. And my friend John Thune, a senator from South Dakota many years ago, said, we need a third category, which is neither fish nor fowl, employee or contractor. We're not quite there yet. We still have to deal with these two categories. Well, California has come down on the side, erring on the side of employee classification. So now, under our labor code, which has almost 100 exemptions to it for people who have good lobbies, consultants and contractors are going to be classified as employees quite a lot. So you really need to be careful about this issue. And it's a weird issue because you could be, here's a real life example. You could be a wedding planner, sitting in Tahoe City, California, right next to the new casino on the Nevada side in Incline, and you're an employee. And if somebody from out of state wants to hire you to do something, well, guess what? They now have got employees in California. They got to pay taxes here. They got to withhold here. They got to get into the system ad nauseum. They're subject to our PAGA laws, our minimum wage laws, our hourly wage and hour laws, paid sick leave, on and on and on, potentially. So it's an issue. Now, let's say you just move across the border and you take up residence in Incline. All of a sudden, now you're a contractor under Nevada law. Well, you're 10 times more employable. It's that weird. It's a state by state thing. And California leads the way on this. Other states have followed. A few other states have adopted similar legislation. Well, what's happened is the Biden administration thinks that that's kind of a dumb result, having different states having different rules, and there should be a national federal classification. And that classification should be California classification on steroids. Basically, the California classification with no exemptions, because I'm a lawyer, I'm not subject to this AB5, which is now in the labor code. So just because another lawyer calls me and says, hey, can you cover a deposition for me? I don't do that anymore. But if I did, if I didn't have this lawyer's exemption, that would make me his employee, his or her employee. But because I got a good lobby working for me, I'm exempt from this law. So, they can call me without having to worry about withholding taxes and me suing them for discrimination and all that stuff. So, anyway, so the Biden administration has proposed this. It's been introduced in the Senate at least once. It hasn't gotten anywhere. It is not federal law. So the Department of Labor has been sort of legislating by regulation in this area. And they have just now recently issued a final rule that very much broadens the definition of an employee, which was going to make it way more challenging for employers in states other than California to classify workers as independent contractors. So this is a Fair Labor Standards Act rule issued by the Department of Labor. It's a final rule. I don't sweat it so much here in California because we've got a tougher rule here. But if you're not in California, you might want to know about that. and we'll see what happens with that. And we do have an election coming up this year. So that rule could become enshrined, or that rule could be, reversed with a pen stroke, as we saw in actually the last two administration changes. You saw, big policy shifts on this issue, this sort of issue. While I'm on that, and by the way, you can look at the Biden plan. I attached it to my slides. It's interesting reading. I attached the portion that talks about this. You might be a little surprised. So on that issue, I also want to talk about the other things the federal government's been doing on this while I can, because this is relatively new. In California, non-competes are generally viewed as void or voidable. And the exception is a non-compete in connection with the sale of the goodwill of a business. So that means that if you're a California employer and you hire somebody and you make them sign an agreement that says they can't compete with you if they leave, yeah, court's not going to enforce that. And two things you should know about that. California has some recent law now that they've always been, they've never been enforceable, but now there are penalties in statute. Now, we had cases where judges got kind of annoyed and said, here you are trying to enforce a law, a provision is unenforceable. We're gonna make you, that's an unfair trade practice, and you got to pay that employee penalty and damages for doing that. Well, that's in our statute now, right? It's now there are plenty of exceptions. Let's see if I got a slide on that. And I don't, but I do talk about it in my book. So anyway, and I can tell you more about it. We certainly talk about it in, there it is, unlawful non-competes, AB 1076. That's the California rule. And you'll certainly hear a lot more about it in my podcast if you're interested in this. But if you're in California, you really got to be, wary of non-competes. The second thing I want to tell you about that is that the Biden administration, and by the way, I think that's a good rule. I mean, Silicon Valley was built on the fact that people have mobility. Employees can leave and start their own company and kind of do their own thing. As long as you're not stealing IP from your prior employer, have at it. Other states are not like that. Texas is not like that. Minnesota is not like that. So again, the Biden administration believes, it's kind of silly to have different states having different rules. And we've seen those races to the courthouse when we get into this sort of dispute. And a lot of it, because a Minnesota court's going to rule one way in this and a California court another. And sometimes you get contrary rulings. So the Biden view is that we should have a national law of this. And how's that being enforced? Through the Federal Trade Commission. They now view overreaching non-competes as violating FTC rules. It's unfair. It's unfair trade practice. Let me put it that way. So you want to be super careful about non-competes, even if you're not in California. I'm not saying they're always going to be unenforceable. I'm saying you better, for now, we have to consult federal law. We didn't have to do that before. We've got 6 minutes left. I think we all know about, I just want to say a couple things about IP. The Federal Defend Trade Secrets Act, we have a federal law of trade secrets. I'm going to talk more about that in a minute, under which you can get punitive damages if somebody steals your trade secrets. The biggest thing I want to mention here is, yeah, you need agreements. You want invention assignments are clearly, carefully drafted. But the biggest thing for startups that they come to me and they say, what is this patent stuff all about? Do I really need those? Well, they're going to help your valuation. A lot of investors really like patents. So yeah, I think they're a good idea. And I'm not so opposed to provisional. I know some patent lawyers say a provisional is a much simpler patent. You get a year to file your utility patent if you file a provisional, but it's lower cost. So a lot of lawyers say don't do it because you might, mess up the claims or whatever. But I'm not of that mind. I think that is a legitimate path. If there's some reason you can't just go to a utility patent. And again, I have a whole chapter on this in my book because there's a lot to it. But from a high level for today, I think you ought to think about strategy when you think about IP. And let's take a big step back. Like, are we going to patent it, or are we just going to keep it secret? If we keep it secret, we can get trade secret protection. Well, which is better? So number one, on the legal side, if we patent it, eventually it's going to be public knowledge, and big company might decide to just steal it and say, what are you going to do, little startup? Sue me? Um, that's the theory. In practice, the little startup will say, well, yeah, I am. I'm going to send you a demand letter and you're going to pay me license fees. And honestly, that is a pretty good disincentive to a big company from stealing it. So that fear, I think, might be a little overblown. However, it's real. The risk is not zero. So if we keep it secret, on the other hand, big companies never going to know how we do it, right? Unless they reverse engineer it, and then we've got no protection. So my kind of big starting point on this is, look, if this is something that can be easily reverse engineered, we better get our federal registration to protect it. We better get a patent. If this is something that can't be reverse engineered, and especially if it's something like software code, it's going to be continually evolving and changing, let's trade secret, because our patent doesn't cover all the additions and add-ons and changes we make to it down the road. So that's sort of my rule of thumb on strategy. So that's number one. Number two, who are we writing the patent for? I'm not a patent lawyer, but I have some right across the hall from me. So, they're always going to ask, who are we writing this for? Because it'll make a difference in how you phrase your claims. If Google is your potential acquirer, you want to write patents that Google would like. So those are two aspects of strategy. Again, you can read more about it. Most of my clients, their biggest asset is trade secret. It's got to be secret. It's got to have value, and you got to do something to keep it secret. That means NDAs. That means security, especially these days. That means not going on a public Zoom and telling the world what you're doing, which one company did during COVID and lost their trade secret protection. So you need to do stuff. You need to be careful about it. You can take a look at this slide at your convenience about the differences and advantages between trade secret and patent. Trademark, I'm only going to say two more things before we sign off. Trademark, don't neglect this. It might be your most valuable asset. When you sell your company, and this is why the online tools are a little scary to me, because I don't know if anyone's told you this. Your logo might be so tied up in your protection of that logo, your ability to keep other people from using it, and your ability and their inability to keep you from using it. And I've had it happen over and over again, where our company has spent many years building a lot of value around its name and logo, and then get a cease and desist letter because they didn't know they were infringing. These days, that's a lot harder to do because we've got the internet. It's so easy to Google it. And it's so easy for them to Google you. So these days, that doesn't happen that often. Nevertheless, you want to protect your mark because your acquirer is certainly going to want to know that. I'm not going to talk about 409A. We've already talked about securities laws. We'll do a whole session on safes at some point. I want to close with something else that nobody talks enough about, and that's personal liability. Especially after the year we had last year in venture, we're going to see companies closing down. Now, I will tell you that what did Abraham Lincoln, did he lose like 6 elections before he became president or something like that? It's kind of the same with startups. First one might not work. Second one might not work. I tell people, I have a client who he's got a unicorn now that he's a founder of, but the first dozens of companies he formed, at least, or dozens of ideas, I should say, dozens of products, they didn't work. And if he'd have been personally bankrupted by any of them, he never would have gotten to the prize at the end in his iterations. So we got to avoid personal liability for you. And these are the categories. Taxes, always keep your taxes paid up to date. Wages in California, officers, directors can be held personally responsible for wages. So you don't want to stiff your employees. Someone once asked me, how do I avoid being sued for fraud? And I said, I got an idea, don't commit fraud. So be scrupulously honest about what you tell people and don't ever misrepresent an existing fact. You can be as wildly optimistic as you have to be about the future, but not about existing facts. Fiduciary obligations, as a director or officer, you owe obligations to your shareholders and in some states your creditors. Securities laws we talked about, you'll have personal liability if you violate a security law. You can't hide behind your corporate shell. And then finally, contract, read your documents. Your landlord might want you to guarantee a lease. You better think twice about that. Know what you're getting into. I'll promise you your corporate cards are personally guaranteed. So don't think you can walk away from all that stuff if things don't go your way. So be forewarned. Alrighty, my name is Roger Royse. I'm a partner with Haynes and Boone in Palo Alto, California, heart of the Silicon Valley. And this has been our presentation on startups. This is my first book, Dead on Arrival, How to Avoid the Legal Mistakes That Could Kill Your Startup. Happy to send you a digital copy if you'd like one, or you can find it on Amazon. My latest book, 10,000 Startups, Legal Strategies for Startup Success. Same with that. And I am going to stop the share and open it up to questions. All right. I believe that my sharing has stopped. And hold on just a second. Let me open my chat box here. All right. Yeah, if you have a question, could you put it in the Q&A box? I don't have to go so many different places. Will the recording be available? Yes, I'm sending that out. Okay. What are some useful, commonly used digital resources or apps for legal research in California? Well, stepping back, I think it's a great idea that you go do your own research, but unless you do your own brain surgery, I would be careful about actually implementing what you found. I think you need to be informed. You need to it's like a doctor. You need to tell them what it is wrong and what you need and what you want checked out, and et cetera, what your goals are. So it's good to do the legal research and have an idea of what you think the answer might be. And the commonly used resources, the ones I use, are paid services: Bloomberg Law, LexisNexis, Westlaw, and I've got access to all of them. And then the secondary sources as well. And those are most common. The free ones are FindLaw, which you can get on. I think that's free. Maybe that's subscription. I have that one as well. Or the statutes. It's pretty easy online to find lots of. And by the way, you should figure out a way, if you are going to do that, to make sure it's up to date. The law is an ever-changing thing. And just because the law changes, people don't update their blog tests. They don't, sorry about that. They don't take stuff down, so be careful about reading like blog posts about the law, because those could be outdated. All right. Would you trust AI-powered chatbots to recite a law to you without the legal jargon to help you read faster and more efficiently? You know what? I did a whole podcast on AI, 2 of them, in fact, on AI and the law. And I don't know if it'd be of interest. It'd be a good session because things are developing quickly and it's super interesting. But with regard to your question, I would never use AI for this. They get it wrong. They hallucinate. And it doesn't happen often. It happens enough where I'm not even interested to hear what they have to say. To be honest with you, I know that's harsh, but the tech is just not there yet. It's based on data, and the AI chatbots you get online, they're going out and scouring the entire internet, so they're going to come back with whatever they might have found, and that's just not good enough for me. Now, you said for you, would you trust it to read faster and more efficiently? Yeah, I think that's a good place to start, but I would not rely on it. It might give you a good background on kind of the very simple, settled issues. There's a famous case here about a lawyer recently, I guess not so recently now, but who was disciplined by his state bar because he submitted a brief and he used AI, a chat box, and he said to the AI, hey, go find me some cases that stand for this proposition. And the AI interpreted that to mean go write cases that would support this proposition. So it just made them up. made up read all the cases on the proposition, and then just made up the captions, made up the case names, made up the sites, made up an entire case text and said, here are the cases that support your proposition. Those cases did not exist. That lawyer put them into a brief, filed it with the court. Some clerk at court went, looked it up, couldn't find the cases and said, what are you trying to pull here, pal? He was disciplined. So yeah, AI is not there yet. I'm not going to use it. If you want to use it just for background, that's okay. Don't rely on it. Okay. All right, here we have a student who is disrupting the information industry. Should I just delve in with the idea or wait till I take in appropriate cash? You'd be surprised how many clients I have that live in dorm rooms because that's just the nature of this business. In fact, I remember one time, it was a while ago, I remember this banker called me up that I knew and said, hey, I got these 3 kids here in my office and they want to open a bank account. And they tell me you're his lawyer. I said, yeah, I am. That company actually did really well too. Very successful startup. Yeah, should I just delve in with the idea or wait till I take in appropriate cash? So I'll just tell you what most companies do. Founders have a little bit of skin in the game. They put enough money in the game to kind of get, and we're going to talk about all this on the 29th, by the way. Put in enough money to get the company formed, kind of maybe just not a lot, enough to kind of get things rolling. And then they do that first friends and family round, right? Where they talk to the rich uncle or whoever, the people that are just going to take a blind leap of faith and give them money before they might not even have a beta yet, right? That'll get them to that next step. So the answer is you delve in with the idea, expect you're going to have to put a little money of your own into this. Please don't use your 401k. Please don't mortgage your house. Just don't do that. If that's where you are, if you can't, it's like gambling. Think of it going to Vegas, right? If you can't afford to lose it, then don't place the bet. All right. And then once you get to maybe even pre-beta, then you can go out to, you can have that talk around the Thanksgiving table about, hey, how about you help me out here, my favorite cousin. Our founder started the company, later brought in a co-founder as a normal practice to structure the share vesting in such a way that the primary co-founder is 100% vested and the later co-founder has a normal vesting schedule. It depends who I'm representing. That question. I will tell you that in answer to normal practice, no, everybody has to unvest. And I'm not trying to, I'm not the bad guy. I'm not trying to protect, her against you or him against you. I'm protecting the company against all of you, because if something happens to any of you, the company needs those shares back. They got to replace you. That would be the more common practice. Does the founder write a promissory note to himself for monies invested, or is it compensated by stock? If there's a funding round, it'd be nice to have the promissory note paid off to pay personal debts incurred for the biz. Okay, good question. In fact, I'll go one step further. Not only money invested, what about your time? What if you say, geez, I've been living on top ramen for the last 3 years. I think I'm owed some back salary, so I'm going to just put that on the books. There's a tax issue with that. I'm not saying you can't do it. You have to structure that carefully. But getting beyond that, I think the founder, I think they can do that, but just be prepared. You might have to take that debt off of your balance sheet before the investor will come in. Just be prepared. They're going to say, hey, that's your contribution. I don't want my money going into the company and right back out into your pocket. So be prepared for that. And you might be so prepared for it that you don't even bother in the first place, because that's just one more hurdle, right? One more thing you have to argue about with an investor. So that's one you should be a little careful about. What to do if the co-founder did contribute to startup during the employer's working hours? Boy, that's a problem. That's a real problem. I would go to the employer and get a waiver. That's what I would do. And I know that's going to be an awkward conversation. but I don't think I have a silver bullet for that. That's one I probably don't want to know. When you incorporate the company, do the owners get shares based on vesting? Does that only apply to later co-founders? Like I say, that's everybody. I think best practice is everybody always. By the way, 20 years ago, it wasn't like that. We'd sit down and have these conversations, and people would sit around a table, and I'd tell them about vesting, and I'd always have to explain it and understand it, didn't like it, and why am I the bad guy? These days, it's not the case. Everybody just understands that. If you have a question, put it in the Q&A box, and I'll get to it through Q&A. I'm not really looking at the chat unless unless there's something wrong. All right. Where were we? In websites, do most of these laws apply? Not sure what you're referring to, but I do want to pause on that for a minute because that did not make my top 10 list, but one of these days it will. Privacy law. If you're on a website, you're collecting personally identifiable information, which is super easy to do on websites now. You get an email address, sign up for my newsletter, give me your name, all that stuff. In California, at least, you're going to be subject potentially to our privacy laws, and in other places as well. It's a big issue. It's one of those things you got to put on a checklist, which is on my checklist, by the way. Do we need, how robust a privacy policy do we need? Websites also, that's advertising, that's public. You can violate the securities laws against solicitation on a website. You can violate false advertising laws on a website if you're not careful. I talked to a reporter last week. Sorry about that. I wonder why it keeps doing that. I talked to a reporter last week who wanted comments on somebody who had violated the securities laws of a representation on a website. It's a real thing. All right. Which type of corporation to register? Is this a strategy to consult legal or accountant? Well, yeah, you should, first of all, always keep your accountant in the loop. If the accountant is not on board with what we're doing, I want to know now. I don't want to know in April of next year when it's time to file the return. And plus, if they have a different opinion, I want to make them part of the problem and try to resolve that issue up front. For example, I had an accountant recently that yelled and screamed that we incorporated in Delaware. Why would you do that when it's so much easier to incorporate in California? Well, that's my whole presentation, really. What's the simplest way to file an international trademark? I'm going to defer to my trademark lawyers on that, but you are right. Trademarks are local. So you file in the US, you get US protection. In my experience, I'm not a trademark lawyer, but I see enough of this to know that you basically file where you want protection. That's where you file your trademark. It's challenging and not meaningful to get patents for certain types of software. Is that true? If so, why is that? Yeah, okay, that's a big question. So it used to be you couldn't even patent software. Everybody tried to copyright it. You still could copyright it, I suppose. But then people realized you get better protection through patent. And then the law changed where business processes are not patentable or not easily patentable. But then the industry changed where people figured out how to write those claims. Clever patent lawyers can write those claims so that the software actually does manipulate a machine and becomes patentable. So that's kind of it at a high level. So the answer is it depends, but we have to take a hard look at the software. My opinion is most of that's going to be protectable under trade secret. But like I say, if it's something that's easily reverse engineered, I think you want to, you definitely want to consider talking to a patent lawyer. What comes first in patent, IP, trademark protection? I'm sorry, friend, I don't understand your question, but I think what you're saying, because people have this idea that IP so a patent and trademark are two completely different things, right? Patent protects an invention, trademark protects a mark or logo. or sometimes a name. So they're not interchangeable, really at all. I guess sometimes, they could be. I suppose you could have well, I can't imagine a trademark that'd be patentable, but you could have a trademark that's subject to copyright protection. You could copyright your trademarks, okay? But that's getting a little arcane. I think the real question here, because sometimes people view this as things sort of graduate. Tech evolves. It starts out as a trade secret because it's a secret idea. It's a process. And then eventually it evolves to the point where it's a patent. And that's not really the right way to think about it. I think they're two completely different things. Like your patent and a trade secret are not the same. A patent is a federal registration. And again, follow my rule as to when you would patent them. Now, I've sat on IP webinars with IP lawyers and listened to them for hours, dance on the head of a pin as to the difference between trademark and patent, and what should be patentable and what should be trademarkable. I'm just highlighting the high level issue. You definitely want to talk to an expert in the field if IP is important to your company. All right, there's a question. Let's see. What are the steps to start a company on a visa? Yeah, so I'm not a immigration lawyer, but I have a partner who is. And I'd say more than half the companies I work with are from other countries. So I see this often where somebody who's from another country and they're not here on they're here on some sort of visa. Maybe it's a tourist visa even, but usually a business visa. And they say, can I start a company? The answer is yes, you can. You can even be a director of that company. What you can't do without complying with the immigration laws is be an employee of that company. And the strategy is often, it's one of two things. I have a company overseas and I want to bring all my people to the US. In fact, I want to make a job for myself in the US so I can come over. So they'll form a company in the US, and that's possible. You do have to have, I understand, a substantial business here, and then eventually you start bringing your foreign employees over, including yourself. I don't think you're able to do that on day one. The second scenario is, I don't have a business overseas. I'm a college student in the US. Can I start a company in the US? Yeah, you can, but you're not going to be employed by that company. You're not going to be drawing a wage from it. But lots and lots of companies, you don't have to be a resident here to be a director. You don't have to be a resident of the US or a citizen to be a shareholder. You don't have to be a US person, even to be an officer, okay? But you do have to comply with immigration laws to get paid. All right. I am scrolling down. How can I be infringing a patent before I publish a minimal viable product in the market? I know competitors in my sector that have something similar, although not as broad as in my area. So let's pause on patents. A lot of questions about patents. So the problem with patents and why we think they're important, or one of the reasons why, is what I'm worried about is that there's a patent application out there you don't know about. And we have priority is first to file here in the US. And you might be, and this happens, you'll be buzzing along with your company thinking everything's fine. Then all of a sudden a patent pops up and issues. And now it's not fine. Now you're infringing on somebody else's registered patent. Okay, so that's where you're going to have an issue. So if you can get your patent filed first, then you got some comfort, and that's why they're valuable, right? You have some comfort that no one's going to kick you out of the market. I mean, it could happen. People can challenge the patent. Happens all the time. It might be a junk patent. But in a perfect system, you're going to be able to keep other people from competing with you with that patent. What's the right time for a startup to reach an attorney like yourself? I'm different than most. I want to get in as soon as possible. I want to make sure everything follows the plan, right? What did George Foreman say? You got to plan your fight and fight your plan. Well, I want to plan the fight early on. Let's see here. somebody's looking for an investor and they're in a foreign country and they haven't gotten a lot of interest in the USA, we're going to talk a lot about this on the 29th. But basically, I think, where do I start? Before COVID, to try to raise money in the US, you had to be a US company. In fact, here in Silicon Valley, you not only had to be a US, a Delaware corporation, you had to be here in the Valley physically. COVID changed that a little bit because the VCs got sort of comfortable with working with people they only met on Zoom. And that was good. And since COVID, they've gotten a little more comfortable than they used to be. However, so I'm seeing VCs now invest in foreign companies that wouldn't before. And some of it depends on the country. And some countries are just way harder to invest in because the law is so much different than ours. But as a general rule, you have a big competitive advantage. If you take your if you're getting money from the US, you move your foreign company into the US and then have the Delaware corporation go out and do the financing. You're way ahead if you do that. Okay, so that's my answer. And the way we typically set these deals up, I just did one with the Japanese company recently, is everything happens at or near a big close, right? The inbound migration and the investment all come in. So you can go to the investor and say, look, we'll have you a US company at close. Now that doesn't always work because oftentimes the investor will say, I'll tell you what, you come back after you've got a US company, then we'll talk about investments, a little bit of chicken and egg. Because the startup is saying, well, I don't want to move to the US unless I know I'm getting investment. So I don't know if I have a good answer to that, other than what I often will do is form a Delaware corporation. We'll set it up in parallel to your foreign company. We'll put in place people, at least we can tell the investor, look, we've got our Delaware company. We do have to finish the migration part, the inbound, moving the foreign company into Delaware, but we're halfway there and we will have it there by close. That's kind of the best I can do on that issue. The other, other couple things I want to warn you about that is that they call that a flip, an inbound flip. Foreign company just flips, so now it's a US company. So, all right, we got US company on top owns foreign company, and investor invests in US company, which owns the foreign company. Very common. I do that all the time. It's usually simple as a US matter. In fact, I have a whole podcast on this, which you should go listen to. But it can be really expensive as a foreign matter. So we got to get foreign tax counsel involved. And I have a hack if it is. So if you're in Canada where they're going to tax you on the US flip, well, you don't want to do that. So what we might do is maybe a parallel stapled entity. Or we might do, in China, we oftentimes do these arrangements where it's just a big license of all the assets into a parallel entity. So there are ways around it. They're complex, they're expensive, but ideally we like to just do the flip where foreign stockholders contribute all of their assets or stock to US company in exchange for stock in a US company. The second thing I want to warn you about, and this gets overlooked even by good lawyers, is that everyone assumes that that's non-taxable because, gee, why would the IRS ever tax a company for coming into the country? They were non-taxable because they were sitting in Japan a minute ago, and now they're taxable because they're in the country. We want to encourage them to do that, right? Yeah, well, unfortunately, that's not always how it works because if there are US shareholders of that foreign company, and if it's got earnings and profits, current or accumulated, or even if sometimes if it's got appreciation, which it always will, then those US shareholders, if they're not careful and if they don't plan this correctly, are going to pay some tax on the inbound inversion, even though all that happened is, poof, I had Japanese shares before and now I've got US shares. So you need to be super careful about that one as well. What's the right stage to reach out to professional angel investors? So again, this is a good topic for, hold on, let me close my screens, a good topic for our 29th, our February 29 event. But I would say that the right stage for an angel investor, just at a high level, is going to be, hold on, let me put this in the chat. It's going to be, so the angels, we always say you don't need traction for an angels. That's not really true here in the Valley. Most of the angels I work with, they want to see traction. Your friends and family, they'll finance you if you got a beta and even before. But if you go out to the angels, they're not like the VCs where they need to see scale or scalability, but they are going to want to know usually that somebody will pay for your product. That's attraction. Someone will use it. And some angels, the earlier, because there's different kinds of angels, the earlier angels, they'll take a flyer on a beta because they're getting a super low valuation. But around here, the angels have lots of opportunities and they're super sophisticated. And they're going to say, why would I give you money when here's a company that's already shown me that someone will pay for it? By the way, on traction, this is where companies get in trouble. You got to be careful about that because it's so important to the investors that they know people are going to buy your product. That just because people are using your product, that's not the same as paying for your product. Because you're out there giving, and I do a lot with agriculture tech, and I see a lot of companies giving their product away to farmers just to get them to use it. That's a great strategy. I have no problem with that. But you better be clear with the angels, because the smart ones will ask that next question. Oh, because you'll say, oh, look at all the customers using my product. The smart ones will say, are they paying for it? But the not so smart ones will forget to ask that question and then feel a little cheated when they find out that you gave it away. So this is fraud versus puffing, I guess. Somebody asked for my contact information. I'm putting that in the chat. You know what? I did not do those. I didn't give you my podcast. And I'm going to give you not only the Apple podcast link, but it's also on Spotify, Amazon, Google, and Buzzsprout. I think Google might have discontinued theirs, but if I can pop it in here, there you go. Okay, last question. Who all should, I think they're saying, who should your team consist of at a minimum? Yeah, thanks. So again, I'm a little different. I'm kind of more of a team player on this. Definitely a lawyer, but I like to get the accountant involved early. I want to make them part of the problem right from the start, because every once in a while the accountant might not know what we're doing, or there might be some special issue or something about the founder that's unique. Maybe they got tons of losses they need to soak up, or maybe they're foreign and they didn't tell me, or whatever it is. I like to get the accountant, and if they don't have one, I'll recommend one. Get an accountant involved early. Maybe they're trying to leverage some R&D deductions, so we might do a different kind of structure. Maybe they're way more concerned about, maybe they think they're going to be profitable and don't want to pay self-employment taxes. So lawyer and accountant at a minimum. I go further than that. So I kind of like you to have your banker lined up, because getting a bank account is surprisingly, for foreign companies coming inbound, it's harder than you might think. So I want you to be working with a banker that I know that's going to get you set up, so we don't run into this problem that you got no place to deposit the money. So, so I think that's the team as a minimum, accountant, lawyer, banker. Now I have a checklist I send out to all of my startup company clients. And on that checklist, it says, here's all the legal stuff you need to think of, all the stuff we talked about, plus IP, plus privacy, and plus some regulatory stuff, depending on the business. But more of the checklist is, here's all the non-legal stuff I want you to think about now, okay? Just to make sure. I'm a big believer in process and checklists. And on that, I have all the people I mentioned, but I go way beyond that. Do you have real estate? Do you need a Silicon Valley space? If so, here's some resources. Do you have employees? Do you need payroll service? If so, here's some resources. Do you need benefits? On and on and on. And I think it's really helpful because it kind of focuses people on all the things they need to know to start a business. Okay, with that, it is at 10:30 Pacific in California. I want to thank you all for being here. As I said, my name is Roger Royse, Haynes Boone, Palo Alto, and I am going to be following up you on email